Ladies and gentlemen, gentlemen and ladies, ladies and gents, I keep telling people that I serve the true God. His name is Jehovah. And I say that because he's the one who allows me to be that genius. I can't take credit for it because I promise you I am not that much of a genius that I could have come up with this all by myself. It is just not possible. We told you that it was genius that we started an arbitration association. Did you not know that private arbitration associations are recognized in law? Did you know that? Oh, by the way, this is dealing with, and I'm going to let you know, see, we don't handle consumer contracts. We don't handle consumer arbitrations. But did you know that if you need a consumer arbitration and you fall below the poverty line, that your arbitration is to be free? That's right. In California, they have it. There's a fee waiver. Remember, we're going to be providing a fee waiver and reduction program. And that is the other interesting thing is, do you know that they cannot demand you pay fees in order to participate in arbitration in California? That's this section right here. I did not know this prior to today. The only thing I was interested in is whether or not one could be party to an arbitration by private arbitration. I'm looking for, give me a second. Nope, it ain't none of these. Is it here? Is it here? I think it might be. Nope, it ain't there neither. It ain't there. This is where we just was. These are the California ethic rules. Now, the California ethic rules, what they require of an arbitrator is to meet these rules right here. Hold on. The arbitrator fails to comply with his or her obligation. Well, of course the arbitrator must comply with their obligation. The arbitration complies with his or her obligations and makes a disclosure within 10 days of the service of a notice of proposed nomination and appointment. And based on that disclosure, a party serves notice of disqualification in the manner and within the specified code 1281.91. But the parties can't do that, ladies and gentlemen. The arbitrator may require disclosure more than 10 days after the service of notice of proposed nomination and arbitrator, and based on that disclosure, a party serves notice of disqualification in a manner as prescribed by the rules, or, pay attention, a party becomes aware that an arbitrator has made a material admission or material misrepresentation in his or her disclosure within 15 days of becoming aware of that, blah, blah, blah. Ladies and gentlemen, this is for the state of California. You're going to find that for the state of California and other states, the qualifications for an arbitrator is the same qualifications for a judge or any other person who's trying to seek some type of office. You don't need a bachelor's degree. You don't need a master's degree. But for us, those of you who are coming in, we're accepting only individuals who have bachelor's or master's degrees for the time being. Okay? That's just to let you know. All right, at SAA, ladies and gentlemen, when you find that the rules are what the rules are, see, these are the ethics standards for neutral arbitrators and for contractual arbitration. These are the ethics standards. This is the entire document. Definition, duration of duty, general duty, disclosure, additional disclosure, arbitrators' duty to inform themselves about matters to be disclosed, disqualification, duty to refuse gifts, bequests, favors, duties and limitations regarding future professional relationships and employment, conduct of proceedings, ex parte communication, confidentiality, compensation, and marketing. These are the rules for the state of California. These are general rules, ladies and gentlemen. These rules apply to everybody. I saw something that said lawyer, so I want to key in on that because it caught my attention as I was scrolling down. Lawyer in the arbitration means a lawyer hired to represent a party in the arbitration. A lawyer for a party means a lawyer blah, 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 blah. These are just their terms and identification. With our arbitration, if it's in person, a lawyer is not allowed to speak on behalf of his client. He is only there to counsel his client, but he cannot speak on behalf of his client. And there's no law that will require us to require anything other than that. Can he tell the client what to say? Of course he can. But the arbitration is not between the lawyer. Whether he's representing a company or not, an actual official from the company has to show up if it's an in-person arbitration. Other than that, the presentment of documentation and information, that's done solely electronically. It's called ODR, Online Dispute Resolution. And we are providing for the basics online dispute resolutions on a regular basis. Ladies and gentlemen, this video is just to let you know that the starting of an arbitration company was the best thing in the world we could have done for you and for us. Because as I told you, I showed you today where we have two separate courts dealing with the same person, denying her remedy simply because they said so. See, the courts are supposed to be open to everybody. Did you know, most of you are not aware of this, but an individual wrote his habeas corpus, pay attention, habeas corpus petition, he wrote it on toilet paper. And do you know, no, this was clean toilet paper, people. Get your minds out of there. God. All right. Did you know that the court cannot discriminate against you because of the format for which you present your presentation to the court? That they must hold you to a less stringent standard than an attorney? Well, they didn't do that for this young lady. See, I have the habit of not wanting to follow those stupid rules, those stupid policies, those stupid guidelines for it must be on this paper, it must conform to this, it must do this, it must do that, it must be on pleading paper. I'm not pleading with you. I'm not submitting to your jurisdiction. You must be out of your mind. No, what I'm going to do is you're now changing the terms of the contract. You see, we have a constitution. The constitution is a contract. It's a treaty. It's a charter. It's a contract. You're now changing the terms of the contract, so I introduced another contract. They never responded to our contract. Oh well, now we go to arbitration. Oh, and yes, our contracts you can take to any other arbitrator and they will have to deal with the contract according to the terms of the contract and nothing else. But the only thing, you take a chance of that arbitrator getting together with some judge or some attorney and figuring out a way to get around your arbitration agreement. Our job is not to get around your arbitration agreement. As an arbitrator, we must follow the rules. The rules say that our power, when I say our, I'm talking about SAA, not me. I'm not part of SAA. I just help form the organization, but I'm not part of SAA. I listen in on their meetings only for guideline purposes, only to tell them what the rules are, the laws are, and what the policies are that they must follow. But I have no control over that organization. It's not mine. I'm just the creator. They have their own board. They have their own ownership. I have nothing to do with SAA other than referencing. I wanted to become an arbitrator for SAA, but I can't do that until I get rid of my cases. If I were to do that. But I'm not sure. And then I'll have to disclose everything. Everything. And I don't mind doing that. But let's get back to the facts. Ladies and gentlemen, what we are doing is simply providing a service. Okay? An arbitrator who is subject to these standards and who is to serve impartially, whether selected or appointed, jointly by the parties or by the arbitrators selected by the parties, by the court or anyone else. Please understand, ladies and gentlemen, we are complying with all of these regulations because these are basic due process requirements. Nothing more, nothing less. Okay? We are complying with the statute. So we are going to make sure that we comply with the law so that we cannot be held to have violated the law so that our arbitration awards can be vacated. That's why no award will be for an amount that is unreasonable. The amount has to be reasonable, not based upon how the arbitrator feels or what the arbitrator thinks, but reasonable based upon the case and information presented and the issues presented. Just that simple, people. It really is just that simple. See, the unique thing about incarceration, the incarceration thing at $1.6 million, that is huge for a deprivation of rights. The court would never, ever equate $1.6 million for 3,142 days of incarceration. The courts would never do that. Why? Even though the law recognizes that such is a reasonable amount, the court would never do that, because then they would have everybody else coming with their cases about unlawful incarceration. And what could they do? Lord have mercy. But what we're telling you is that by law, we can only go according to the terms of the arbitration agreement and nothing more. Just that simple. So we're putting the information out there for you, and as we said, if you're interested in starting your own arbitration company, I would strongly suggest people like Yusuf El Bey. Yusuf El, I have respect for that man to a level that he couldn't understand. So that's why I mentioned his name. I would strongly suggest he looks into starting an arbitration company and understanding this process. And Jonah Bey. Now, the reason why you only hear me mentioning Yusuf El and Jonah is because they're the only two people I recognize that's still here. They're the only two. I don't see anybody else here doing what we do. So I'm now reaching out to them, letting them know about this process, that if we had known about this in 2000, in 1998, in 1997, ladies and gentlemen, most of what most of you have been through never would have happened, because we would have done so much to have prevented it from happening. When people were discharging their debt dollar for dollar with the use of A4V, all of that would have been taken care of. This whole sovereign citizen junk that they set up here and passed all of these stupid laws. Look, here's the thing. They would have had to pass a law specifically for individuals who would have completed this process. That's going to be the problem. Because now the cat's out of the bag. If I was meant for something, this is the something I was meant for. Because this helps everybody. Please, 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 as James Brown would say, do not email me asking your personal questions. I cannot handle your personal questions in a moment. And as a matter of fact, hold on one second, ladies and gentlemen. I got something for you. Ladies and gentlemen, if you take a look at the clock here and go back 5 seconds, you'll see that there's been at least an hour and a half that has gone by since I put you all on pause. Because I said this video was going to be only a minute, but as I told you, my life doesn't work like that. I'm up at 6 o'clock every morning and I don't get to sleep until after 10 every night. Sometimes, now don't get me wrong, I'm not having, after I started taking Alterel, and I gotta advertise Alterel, y'all. I gotta advertise, hold on a second. Gotta advertise Alterel. I just put in Alterel and they put Walmart, but we can deal with Alterel. Ladies and gentlemen, just gonna tell you, I took this natural sleep aid, and it is a natural sleep aid in a 60 count. Oh, look, they're only $18 now. And it's roughly about $18 for 60 count. And don't worry about no shipping. Just go to Walmart. It's in the pharmacy section. It's Alterel. I guarantee you it works for me. And I'm the guy who told you no matter what I did, I could not get any sleep, that I would stay up 4, 5, 6 days in a row. The longest that's ever been was 9 days. Look, you cannot function without sleep. So I got Alterel, but I got it because it was all natural. When I saw that it was all 3 natural ingredients, because I had been trying so many sleep aids, over-the-counter, prescription, and the ones that were prescription were all chemicals. And then they tried to give me some junk that just, that didn't make you feel like you were you. And I couldn't stand that stuff, so I immediately stopped taking that junk. So I had to find something. Alterel. That's right. I took one, 14 hours of sleep. The very first night I took one. Then I took it, and then all of a sudden it just stopped working. And I couldn't figure out why. And so I would wait about 7 or 8 days and I'd take it again and it would work. But then it stopped working again. And I couldn't figure out why. Well, what I did is I took 2 one day by itself without taking any other additions. Then I waited a day and then took 2 more at the same time. Then I waited another day and then took 2 more. And I haven't had to take that stuff every day, even every other day. I haven't had to take it again in 7 days or 15 days or 20 days. My sleep routine is back on course. At 9 o'clock, I am sleepy, ready to knock myself out. but I don't have to go to sleep, so I'll stay up, and then I'll just eventually turn off the television and go to sleep. So all Terrell. Ladies and gentlemen, here are some of the questions some of the people have been asking. For mortgage contracts, do all the previous mortgage servicers need to be notified? And if so, if they sold it to another one prior to the current mortgage servicer, the answer is no. You're not dealing with the mortgage contract, you're dealing with the change in terms of agreement, and when they sell it to another mortgage servicer, they're changing the terms of the agreement. Well, the agreement allows them to sell it to them. No, when they send you out a notice demanding you pay them, that's changing the terms of the agreement, because the original agreement doesn't say that you're required to pay the new servicer. It says that they're allowed to transfer the mortgage, but ain't nothing in there saying you have to pay another servicer. Okay, so they just changed terms of the agreement. You do the contract. Okay, the previous mortgage company enrolled me into the HARP program. Will this have any effect or turn up any issues? Well, first of all, it's a new contract. How can it interfere with the HARP program? Because it incorporates that program. But then if you want to include the HARP program in the contract, you'll have to send it to the agency who controls the HARP program. Okay, now pay attention, ladies and gentlemen. These are suggestions. You have to make the choice, because you have to do the research. No one can do this research for you. You're not going to find a single lawyer out there who's going to do the research for you and tell you, all right, this is what you better do. This is what you need to do. Whenever you hear a lawyer telling you what you need to do, he's not giving you legal advice. Okay? He's only making a suggestion. Don't believe me? Go in court and tell them what the attorney said. Okay. Anyway, I am current with my mortgage. Therefore, I am not sure what to put. Would I checkmark breach of agreement? Of course you'll checkmark breach of agreement. The original mortgage is paid off. There is no money, people. It's in the contract where it specifically says there is no money, that they lent you bookkeeping entry credit. Again, we're not here to... I can't think for you. I told you the contract is already filled out, so let me calm down. I'm gonna calm down. Ladies and gentlemen, the contract, when you read it, it specifically states that the contract, the original one, was for them to give you a loan. There was nothing in the contract that stated they were giving you bookkeeping entry credit. Nobody asked them for a loan of credit. They asked them for a loan in order to purchase a home. If you were purchasing it with credit, you should be able to pay it back with credit, dollar for dollar, as the law states. Go back and read the Gold Repeal Act, people. You guys know it as HJR 192. It says that it is to be paid back dollar for dollar in any type of coin or currency at the time that is considered legal tender. Dollar for dollar. So you should be able to use the same bookkeeping entry credit. The contract specifies that. Okay. Whoo, doggy. Now, I understand that we need to get these contracts. Okay, if that's what you understand. 2 mortgages, credit cards, TDAs, utilities, to all of them ASAP. Is it $500 per contract? Exactly. To send to each contract to them and have you arbitrate? Yes, because each contract is a separate matter. The contracts to the mortgage company and the credit card companies, can I combine all of them? You could, but then you'd run into a lot of problems, because you would have to associate how this company is associated with this company and that company is associated with this company and this company, and how they all come together. Oh, by the way, TDA, that stands for Treasury Direct Account. Ain't nobody talking about no Treasury Direct accounts. We don't do no Treasury Direct accounts. I don't even know where y'all getting that information from. Okay? This ain't about no TDA. Ain't never was. Do you have a contract with Treasury Direct? Well, if you do, then you can write the Treasury, but there is no such thing as a contract with TDA. TDA is not an entity. Sorry, I apologize for that. So many people are doing that TDA stuff. Should I start putting mortgage in escrow instead of paying it in order to force arbitration? Look, ladies and gentlemen, That is a good question. Honestly, that is a good question. That is an option that you have. As long as you pay it into the escrow, then the bank will have to bring forth in order to take the funds out of escrow. And they cannot foreclose on you as long as it's in escrow. Here's the other thing. Do you know while you're in arbitration, all proceedings regarding whatever the issues are in the arbitration are stopped? They cannot move forward. That's in the law, but it's okay. You didn't know, now you know. All right, I'm worried about what to say in arbitration. Will I be able to speak with somebody regarding the process before the arbitration starts? No. SAA will provide the information for you, but they cannot counsel you on what to say and what not to say. They are not attorneys. They are not legal advisors. They are not consultants. They are completely neutral parties. They can only provide you the guidelines for what's going on. However, because they have the ODR, okay, it's online dispute resolution process, you don't have to say anything at arbitration. You simply submit the application, it's called dispute resolution request. You submit that information to them plus all your evidence, and then they send it out to the other party and say, we need you to respond to this, and you have to respond by this day, for the arbitration will be scheduled this day. That's all you have to do. You don't have to speak to nobody. You don't have to defend nothing. You don't have to answer any questions. Just that simple. It really, pay attention, it's just that simple. Okay, I'm dealing with 4 court cases for delinquent property taxes. Okay, well right here, I'm going to give this person who wrote this, I'm going to give them some advice. That you're going to give some advice? Yes, go back and read New Hampshire House Bill 1778. New Hampshire House Bill 1778. Notice how it says that your private property is exempt from taxation. According to the Uniform Commercial Code, Article 9, Section 102 and Section 109. Private property, it's exempt from the paying of taxes. If you are not using that property as a rental property, if it is your primary dwelling, you cannot be assessed taxes because you're exempt. It is private property. They can only tax public property. Your right to property, it's called the right to property clause, that prevents them from doing that. Let any judge, let any lawyer, let any IRS agent come and argue with me about that. Guarantee you, I will send them home. Okay. It says, one has a default judgment for foreclosure, and I am wondering if this would stop the foreclosure. Yes. First of all, you have a default judgment. So what you do is you do automatically a motion to vacate the judgment. And then you put in the information about the property being exempt and the court having no jurisdiction. And you also place in your contract into the record and add that case to your contract. Okay. And prevents me from filing a motion for void judgment. No, I just told you to file a motion for void judgment. It says, wondering if this would... No, I just gave you that advice. I didn't read this before, y'all. So that's advice I'm giving you, is to file a motion for the vacate judgment. Okay? A property tax lender named as defendant as well. Yes, you would do that. You would add the... It's not the property tax. It's the county... what do you call it? County treasurer that's doing that. So you bring in the state and the county into your contract. Another court case involving property tax lender and delinquent property taxes with a judgment to foreclose. Ladies and gentlemen, the reason why they want to take your property, they know the taxes don't even amount to that. What you don't realize is if they sell your property, the only person they're going to be paying off is the bank. Okay? So what you do is you do the same thing in the other case. Do a motion to vacate, which will stay that motion there. Do the arbitration, because the arbitration says, well, the contract in the arbitration, because the arbitration says that as long as the matter is in arbitration, the state case, the regular case is stayed. Okay. You have to put in a motion notifying them of the arbitration once you've been given notice that the arbitration is scheduled. Okay. Arbitrations are scheduled anywhere from 15 days to 6 months out. All right. Have 6 mortgages. Could I arbitrate all 6? You better believe you can. Would I still need to make payments while in arbitration? That is your choice. But the thing about the escrow is exactly why you would put the funds in escrow. Because once you get the arbitration award and you go into court to get that award confirmed, then all of that money you had in escrow becomes yours, because you'll get a judgment stating that. Do paid off mortgages qualify for arbitration? Of course. If you can bring up the fact that they issued you the funds and bookkeeping entry credit, which is a common practice as determined by the Credit River decision, not the decision, the testimony by the Federal Reserve, because the bank manager was a representative of the Federal Reserve. Go back and read the case. One and the same as the Federal Reserve. Okay. Testified on the record that they have a common practice of bookkeeping entry credit. Bookkeeping entry credit. What the? Okay. There was no law. They needed to tell you that they were giving you bookkeeping entry credit. Because they did not tell you they were giving you book entry credit in the form of a loan, that's called fraud. They withheld vital facts concerning that mortgage and that loan that, had you known of those facts, it would have changed your entering into such an agreement. Okay, just that simple. That's called fraud, people. Car loans. Have car loans with my good friend. Okay, ladies and gentlemen, a car loan is still a contract. Anytime they do a change in terms of that agreement, anytime they change any portion of that agreement, you have the right to do what's called a conditional acceptance. That conditional acceptance allows you to present to them your contract, your conditional acceptance under your terms. All right, if I have a total of 8 lenders and 8 tax entities, do I include them all in one arbitration, and how much would the cost be? We'll go to the site. The first 5 we cover. The additional ones is an additional cost for the additional ones. So that will be the $700 one. And that's up to a limit. So you have to go on the site. Can you show us on your site what it says? Because I just don't know. No, that's not the email. That's not the email. This is the one right here. Where is it at? Right here. Then we go, home, home on the range, where the deer and the antelope play. Well, seldom is heard a discouraging words, and the skies are not cloudy all day. Ladies and gentlemen, I haven't heard that song since I watched the last Looney Tunes. But I know the words! What's up, Doc? All right, ladies and gentlemen, here we are at the sitcom website. And when you go to the sitcom website, you know, there is one I'm going to show y'all in a minute, but let's scroll down. If it lets me scroll down. It's not letting me scroll down, y'all. Let's get rid of you. That's the problem I've been having, is the reaction time. I just updated the drivers, and so I think it might be a driver configuration issue. So I'll take care of that when the time comes. You mean there is a time in a coming? There is a time in a coming, y'all. She'll be coming home for dinner. Okay, ladies and gentlemen, do you see where it says? Oh, I said 700. Yeah, it's 700. Okay, so it is 700. I got to remember this stuff, because this is not me, people. Everybody thinks that I'm sitcom SAA. Ladies and gentlemen, I'm not SAA. I only came up with the idea for the company. I only came up with the structure, and I'm giving them what the law says. They are coming up with their own policies and procedures. It's their company. So stop it. Many of you guys are trying to say this is me. This is not me. Oh, I'm sorry. You know, I'm trying to keep the screen fixed, but I can't because of the features of the website. Okay, there's a reason why it keeps moving up and down. But anyway, multiple parties, more than 5, is $160 per hour for the arbitrator, for the arbitration, and $140 for the administrative fee. Okay, then $65 per hour for the technician fee. Okay, all of that, we got to make sure that y'all understand. Might as well just use my fingers. Just touch the screen, because it's a touch screen computer. All of that is the $700 plus fees. I mean, plus, you know, the additional blah, blah, blah. Okay, and then it's $500, then it's $980 for the expedited one. All right, let's get here. And then we went to this holiday thing. Ladies and gentlemen, you need to understand that they are still going through the holiday working on people's documents. Now, that's the other thing I need to talk to you all about. Are you all ready? Because I do need to talk to you about it. Now, let me show you why the screen keeps moving. I know many of you are not asking why the screen keeps moving up and down when you get below a certain spot. So I'm going to show it to you as soon as my screen gives me permission. Okay, it ain't giving me permission. There it is right there. See this right there? It's because of this block right here. That's the block that's causing everything to be out of focus and to move up and down. It's because of that right there. Because it keeps filling up and moving and all of that. So because it keeps moving and filling in, that's what causes the bottom to up and down. Okay. All right. So now that we got that, I just want to show y'all something. Y'all ready to see something? Something. And then we got one more thing to show you on the website because it's important that you see this. This part right here I like a lot. And that's this block right here. I want you to see something. I just gotta wait. It ain't doing it now. But these things, these people move. That hand moves, that moves, this hand moves. It's a video. And it is unique. Oh, and by the way, we talked about the New Hampshire law. Ladies and gentlemen, if you go to our site and you click on About Us, you'll see that we included the New Hampshire law on the site. And you go to About Us and what is arbitration and help what corporate offers to contract. That's where it's at. Sorry, I said About Us. It's under help what corporate offers to contract. This information is about us and what an arbitrator is and arbitrator isn't. Okay? And this is on the guidelines for how we help people and all of that stuff. So finally, we're going to click here. It is important that we go here. And sorry, because I'm doing the video, this video ain't picking up. But it is a video and it just don't want to pick up. So we're going to go to contracts. TikTok, give it a moment. TikTok. Come on now. The reason why we're clicking on contract templates, because many people have been telling us they cannot find contracts. So, file location. Really? File location. So you mean that's where the contracts are? There are 3 different links on this page that will send you to the contract page. Okay? See? File location. So 3 different links. Now, some people have said the links don't work. So I just clicked on the contract file location page and look where it took us. Now, contract conditional conditional acceptance. This is the one for the mortgages, the bankers. Now, you'll also corporate off-C is supposed to be offered a contract. This is also identical. These 2 right here. Here's the one for the infant estate. And here's the one where people want to call the TDA. This is not TDA. It's the infant estate gaining control of one's securities contract. Those are the 3 that are on the site, people. And then we have the other documents where you're going to find the actual contract used and the private and public law here and the stipulation, the offer for settlement, the irrevocable power of attorney. All of those documents are here, templates for you just to be aware of the process and how it worked for Mr. Starks. When I tell you that the young man was a genius, he was a genius. He figured out something nobody else had done it before him, and he had success. The only problem with his success is that he amended, and so the public law is not enforced. That's why he's still in prison. That's why he's still in jail. But if he hadn't amended the law, that private law would have been in effect and it would have been enforceable. There would have been nothing the courts could have done because they would have had to go by the law. So he's still going after the law. But I'm trying to get him to understand, and he's starting to grasp it, that we're going to go after his power of attorney that he has in the contract, what gives him the same power of the attorney general. That's his power of attorney. It gives him the power of the attorney general. That's interesting. So, ladies and gentlemen, these are the things that I wanted to bring to your attention. I said I have one final thing to bring to your attention, and it is final, ladies and gentlemen. I put up that's my NordVPN. I put up the information for you about the questions that people have asked so that we can take care of some of those frequently asked questions. But I also wanted to make sure that you all pay attention to this. Some of you just simply have a hard time focusing and concentrating. And it's not because you're stupid. It's not because you're dumb. It's not because you're ignorant. It is simply because life has played its games on you so long, as Larry Graham would say. And because of your experiences in life, and this has nothing to do with drugs, but some people have used drugs and it's affected their ability to focus and concentrate. But this, I'm not speaking to those people. We understand about you, but most people don't understand that there are regular people out there who, because of circumstances, because of situations, because of chemicals, because of the environment, have lost the ability to focus, to concentrate, to reason, to being able to fill out a contract because they can't grasp it, they can't understand it. Please don't email me trying to tell me, but you speaking about me. I spoke with a gentleman this afternoon. He was doing the best he could to try to explain to me his situation. Yes, I answered the phone. I told you it's a hit and miss thing, because the last time I answered that number was probably 2 weeks ago, and then before that probably 3 months. I don't answer the number that people call that I put online. Oh, if you want the number, I'll give it to you, but you can call all day long. I won't answer it. It's 6315 V3. That's the number, 6315 V3. It's on the internet. It's not hard to find. But again, I don't answer that number. And I told the gentleman that. He called me here on the 24th of December, and I told him, what gives you the audacity to be calling me on the 24th of December? I mean, who told you that it was okay to call me on this day? You don't call any other business on this day. You know that all the other businesses are closed on this day. So what in the world would make you think it was okay to call me on this day? And he wanted to explain the situation so badly, and I would not let him explain the situation. I said, no, you called my phone. You will answer my question, and I will hang up. I don't play. I have no empathy or sympathy. Just because something is important to you doesn't make it important to me. There are too many people, ladies and gentlemen. There are too many of you. There's only one of me. I'm not going to let you dig that hole for me and then have me walk into it saying, okay, you can pour the rest of that. You can fill the hole back in. Oh, don't worry about me. I can breathe under dirt. Ain't no way in the world I'm letting you do that to me. So the best I can do for you all is to help put together organizations. So what we're going to be doing, and I got to tell you this story because it's important. Just before that gentleman called, I had looked at an email because we have to make sure that the emails are being responded to appropriately. So I looked at an email, and it was from a gentleman who was saying that, hey, he looked over the contract and he noticed a lot of mistakes. Ladies and gentlemen, those are not mistakes. Those are purpose states. Okay? Yes. Flaws that are left there on purpose, because you're supposed to be reading over the document and making the corrections. Nobody said leave it as is. We said do not change the terms and conditions and all of that stuff. You don't want to do that. You don't want to mess with that. You don't want to add 85 quadrillion dollars and all that other stupid stuff that people do. And about the corporation, the all caps name. You don't want to add anything more than what's already there. Why? Because once you do that, they can declare it null and void. Why? Because Congress did not determine that that stuff was binding. They determined that Mr. Pay attention. They determined that Mr. Bradley Stark documents were binding, that his contract was legitimate. The government has agreed to that information. They haven't agreed to your information. Are you paying attention? So what I'm trying to tell you is, don't get creative. You get creative, you're gonna give them away out of your contract. because that's what they have been in the habit of doing. Go look at the cases where people are arbitrating and have contracts, and look at the way the courts have been narrowly making decisions and determinations. So don't do that. Well, this guy got in contact with us. He says, look, hey, we understand what you're doing. We want to help you guys. We have an organization, and our organization could come in contact with you guys, and we could help each other and all of that. Now, I know he wanted to make money, and I was going to stipulate to him, okay, we can do something like this, but you can't be affiliated with us because the law won't allow that. But because you're not affiliated with us, because you're contacting us asking to be a third party, hey, we can do that. I was going to contact him and tell him that. So you know what I did? I told the guy who called, I said, you know what? I said, prior to you calling, I just responded to somebody in an email regarding the very same thing you're calling about. So give us a week. We will find an organization to help you and people like you with the contracts. Do you know what he said? He said, thank you. And I said, no problem. He still wanted to go on and explain. And I understand that. But I told him I just simply didn't have the time. Gave him 15 minutes of my time, but that's all I had. He wanted to explain everything, how everything got started, how he got to the point where he is, but I told him, I said, that is personal stuff. That has nothing to do with you telling me what you need. Explaining to me how you got here, that doesn't help me with understanding what you need. Which is what I explain to everybody. I don't need to hear your life story. I get to tell you my life story on these videos, but I got time to do the videos. No, I actually don't have time. I'm supposed to be working on something right now. But I've taken a break because I've been working on documents all weekend long, plus all of last week. So I'm taking a short little break. While I'm taking that break, I'm going to explain this to you. We are putting together, well, we're not putting it together. We have another company. We were going to use that guy's company, but when I dialed that number, thank you for calling Verizon. The subscriber you're calling is not available at this time. Please try your call again later. Not even a voicemail. And I dialed the number twice. Ladies and gentlemen, from my own personal phone, I dialed that person's number twice. Person said he listened to my video all the time. I dialed his number twice. Sure did. And he didn't answer. So we're going to go with someone else to help people. We're going to go with someone else who doesn't have a burner phone. I was very disappointed to have somebody leave a number and it's a burner phone. See, sometimes I do call people, but you don't get to call me, leave a number and tell me to call you back and it's one of them little stupid numbers. It's a Google Voice number or something like that. You don't get to do that with me because that ain't gonna work. All right, ladies and gentlemen, ladies and gents, I's got to go. But the one thing I can tell you is once your arbitration process starts, you can notify the court that the only remedy is arbitration. The only remedy. And because the only remedy is arbitration, they can't proceed because the arbitration is the exclusive remedy of the contract. And that is up to the arbitration. And because our contracts has the parties agreeing to the arbitration being done by SAA, the court cannot deny that because the party agreed. Trust me, when it happens, we'll explain to people to catch-22. I promise you. And even if they were to assign a contract to another party, another company, they would still have to go according to the terms of the contract. Ladies and gentlemen, the contract is done to protect all parties. It is not singular to protect you. All they have to do is respond to the contract. All they have to do is respond to the contract, answer each one of the questions for which they have knowledge of, and each one of the questions they are required by law to have knowledge of. Remember, they're the custodian of record, so they also have to provide those records. That's the only thing they have to do. All of it is stuff that they can do. It doesn't cost them a dime. Does not cost them a dime, so they can't say anything about expense. They're the custodian of record. They're supposed to have those records available and produced upon demand to you. So they're the custodian of records. None of the things are things that are impossible for them to do. That's why the contract works. I know a lot of you want to add a lot of junk to it. That's why I'm saying you don't need to. You don't need to add all your personal information. It covers the basic common information that the violations are basic and common violations. You don't have to add in all of the stuff that happened to you 5 years ago. You don't have to add all that personal junk because it ain't necessary. The only thing you have to add is you violated this law, you violated that law, and it's already in the document. So people, all you got to do is go through and make sure of the context. And by the way, the mistakes are taken care of by saying that this document must be construed contextually and not otherwise. So the people who are trying to find the mistakes don't understand that they're trying to construe the document otherwise. You can't do that. The document prohibits the parties from doing that, or the courts. It can be not be construed liberally. It must be construed contextually. It's the instructions in the contract. Remember, the grantor's intentions is law of the contract, law of the trust. A trust is agreement. It's a contract. The grantor's intentions is law of the contract. All right. It's been a long day. Gotta go, y'all. But I'm hoping y'all's had a good time understanding our frequently asked questions and our arbitration and what's the process and the help that is soon to be available to those of you. Now remember, the new corporation that will be formed is not SATCOM or SITCOM, not affiliated with it at all. As a matter of fact, we can't even pay to get it started. That has to be done by another party who's not affiliated. Okay? It's just the law. It's the way the law says that it has to be neutral. But they're going to provide help with the contract. That's all that it is. So, just letting you know. All right. Have a Coke and a smile and a Coke, and we will speak to you the next time. Goodbye.